Welcome to Rebel Chaser. My name is Gail, and I've got several videos for you tonight. The first one is with Judge Rossi. The second one is with Judge McNabb. And then I've got three shorter ones with Referee Winther. So I'll let you guys watch.
We are here in the case of Amy Quinonas versus Andy Dowser, case number 25-05016PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on the respondent, Mr. Dowser's motion to terminate a PPO that I granted in favor of Ms. Quinonas. Looks like I signed that back on June the 4th. So I do note that we have Mr. Nolan here for Mr. Quinonas, or I'm sorry, for Mr. Dowser. Mr. Nolan, would you place your appearance on the record, please? You have to unmute, Mr. Nolan. I can't quite hear you.
Yes, may it please the court, Your Honor, Lawrence Patrick Nolan on behalf of the petitioner, Andy Dowser.
Now, he's the respondent, but that's okay. The petitioner is Ms. Quinonas, but I've already goofed that up.
I'm sorry.
All right. Well, Ms. Quinonas, it's your burden to sustain the PPO in the face of the objection here. So I'm going to swear you in and take testimony regarding the items in your affidavit upon which I granted the PPO. I'll let Mr. Nolan cross-examine you. And I do want to caution everyone that we have a fairly limited amount of time, only about 20 minutes to get through this afternoon. If we can't get all the evidence in, we'll just simply have to continue it and do it at a date in the future. So, but for now, Ms. Quinonas, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And would you please state and spell your name for the record?
Amy Quinonas, Quinones.
Very well. Thank you, ma'am. And in this PPO, I granted it based on unwanted electronic communication and threats. And here, you justify the PPO when, first of all, saying that Mr. Dowser sent an email to the head rugby coach that stated how much he hates you. Was that one of the copies of emails that you attached?
Correct.
Okay. All right. And how did you get to see or read that email?
That was sent to me by the head coach. Originally, Your Honor, myself and the rugby team mom, Tina Harmson, were CC'd on correspondence back and forth. And that particular email, we were removed. And so the head coach, Sean Gent, felt that I should be aware because it appeared that Mr. Dowser was rather upset with me, even though I was not the one that sent the original email to him. I just happened to be the one he attached his anger to, I guess.
Okay. All right. And
I don't know if I'm sorry, Your Honor. I don't know if you need to know what that $20 was in reference to, but
yeah, why don't you explain that to me?
sure. Your Honor, Mr. Dowser had been contacted by the team mom, Tina Harmson, by email, and I was CC'd on it because we were selling raffle tickets for the rugby team, and a parent had reached out stating that one of their family members.
Your Honor, I don't want to interrupt Ms. Quinone, but I think if she's relying on what someone else stated or that, I don't want to continue. I know there's leniency by the court in regards to hearsay statements, but I think that this is about to be testimony by which Ms. Quinones is indicating somebody else stated.
Your Honor, it's in an email, which I may have attached to that.
Okay, if you could
I was
refer me
CC'd on
to
it.
the email, that would be helpful.
Let me see. In one of the attachments dated Sunday, May 4th is an email between myself, Tina Harmson, and Mr. Dowser.
Okay.
It's a quite lengthy email chain, but I believe I only attached the part where he refused to return the money.
Okay, and that's the email. I only have yes, I see it here, right.
Mhm.
I see, and that was the discussion about the $20. Well, and I guess that the key part is where in there, where's he talking about you, Miss Quinones, in that email message?
The email message that I was forwarded from head coach Sean Gent was in response to this $20 he was refusing to give the team back.
Okay, and
Um,
is that where he says I can't stand her? That's referring to you?
Correct.
Okay. All right. I get it. And both these teams are here before her and will be here after her. She's into this because of what she deals with every day, or it's what she deals with every day at school. Now, the message above that does contain quite a bit of profanity, but it appears to be
He's
from Sean Gent to Andy Dowser. It's not directed at you, correct?
correct.
Okay, all right. Well, and so the point you're making there is that in that communication, Dowser's letting you know, on certain terms that he's faulting you for some of what's going on.
Correct, Your Honor. He blames me for him being caught stealing.
Okay, all right. And why don't you point me additionally, I know that when I granted this, I read these at least enough to a point to say, well, it looks like there is, a conduct or communication that could be threatening. Why don't you point it to which ones are directed to you? I am looking at a text here. Um, This is Thursday, 5/29/2025, a ways in. Well, you did it. You should be proud of yourself. Boys program will never be as successful as the girls because of people like you. You're fake. I am real people and can see that. Is that directed to you?
Correct. That was a text message sent to me by Mr. Dowser after his meeting with the administrators at Rockford Public Schools where he was fired.
Got it. And if down there later you say, well, stop contacting me and leave me and my kids alone. And the response is, I don't care, or I don't know who this is.
Correct.
Okay. All right. And can you point me to anything else in there that's disparaging or harassing or threatening that's directed straight at you?
The text message prior to that, dated May 7th.
Okay.
I was informed by Officer Ryan Morin at Rockford Public Schools that Mr. Dowser had
Your
been
Honor, again, I'm going to place an objection
Yeah,
to
we
your.
can't say what he says if it's in a text message that's directed to you or authored by you. I can take a look at it, but if it's just something the officer said, then that's going to be hearsay and not permissible unless I hear it directly from the officer, and we can reconvene and bring him in. However, let's get as much as we can. Is the information relayed in the message itself anywhere?
the there in one of the emails from Officer Morin advising me to get the PPO does state that he was issued a no trespass letter from Rockford Public Schools.
Okay. All right. So that's what, and that's the officer saying, hey, you might want to get a PPO because of this tension or bad blood, whatever it is, and his interactions with supposedly with Mr. Dowser.
Correct. Mr. Dowser had been advised by the school district
Not to be on the property.
not to be on the property, and he has persistently shown up disregarding that order as recently as just a couple weeks ago.
When he shows up, is he making contact with you, or is he just violating the no trespass order or the no trespass?
Two specific occasions, he sought me out personally,
Okay.
which
Has
is
he
why
said
Officer
anything?
Morin suggested getting the PPO,
Got
which
it. And-
one of them is that text from May 7th,
okay.
which is just above the,
Let me
he
see.
was at the field. Mr. Dowser was at the field when he wasn't supposed to be. And he was watching what I was doing, apparently, because he would have not have known that I was, like he said, you guys need to stop and take down the
I
girls'
see.
flags. That he was on the property when he wasn't supposed to be.
Okay.
And watching
In
what I was.
violation of the no trespass. There's no PPO yet, but
Correct.
okay. I understand what you're saying.
And
All
then
right.
on a second occasion, he came back and was waiting outside of the concessions booth where I was working for me to come out the side door where the employees come out, or the volunteers rather. And I was informed by the athletic director to stay in concessions, and he had
Your
called
Honor,
Officer
again,
Morin.
I'm going to object to what somebody told. It's very difficult, as the court can appreciate, when I have the witness testify as to what people told her when those people haven't been named, or I have no way of verifying. Ergo, the hearsay rule.
No, I totally understand, Mr. Nolan. However, in this case, she did say it was the athletic director. She's not offering it for the truth of the matter, asserted anything said about Mr. Dowser, but rather I think she's offering that for the fact that the athletic director said, hey, this guy's out there. You should stay in the concession stand and not go by where he is. I think that's what that was offered for. Yeah. Okay. All
That is
right.
correct,
Thank
Your
you.
Honor. There was also Officer Morin, I believe, did have to file some paperwork as he did again violate that.
Again, objection, Your Honor. How does she know that he had to file paper? She's indicated that he was fired. He's not even employed. You can't fire somebody that's a volunteer. They either quit or it's not a job that he was being paid for. It's a volunteer job. This is a couple of coaches in regards to, and I see Miss Quinones laughing and shaking her head, but I'm serious. This doesn't rise to the level of a PPO. I understand the court's reasoning and filing it on any ex parte basis on filing a PPO because it's a very limited period of time and somebody can come in and object and have a hearing like we're doing now. But this is a situation where I don't know what all these people told Miss Quinones, but I do know he wasn't fired from the Rockford Public School because he's never been employed there.
Sure, he
he was
might
a
have been a no trespass and told his volunteer position was ended, but you're right, he was never an employee. Wasn't
correct.
a termination in that
If,
sense.
if I may, Your Honor,
Yeah, go ahead.
he actually was employed by Rockford Public Schools, all club sports, the Rockford Public Schools. There's even a current job opening for the new head coach position for that team. All employees, and by that it doesn't mean paid or not paid. However, there is a stipend associated with that head coaching position. And all volunteers are in essence employee of Rockford Public Schools. I myself work for Rockford Public Schools. As a volunteer, as a parent volunteer, as a volunteer coach, an actual coach, a coach of a club, we're all hired, background checked and approved by the school district. In his position, there is a stipend associated with the head coach, even of a club sport. And
Yeah, so
as I
technically,
submitted in that,
there are some indicators of employment,
yes,
though it's not the same as your position, for example, where you are a full-time employee of the school with a pay rate and a title and all that stuff. Right, and I
correct.
do remember I have said on the Eastern Rapids a couple club sports boards here for crew and wrestling, and it's a similar thing where the athletic director still has the say over hiring and firing. They still do all the background checks, though the parents, in the case of club sports, of course, finance the team and wind up paying the stipend through fundraising and that sort of thing. So at least that's how our system works. So I'm a little bit familiar with it. Well, and I guess what I'm taking away from this, Ms. Quinonas, is based on the content of those messages, saying, you know, where at least Mr. Dowser appears to say, you know, you're fake. I'm real people. I can see that. And then later, you know, he sent you an earlier message saying kind of get your flags off the field, you know, a little more team related, but you're saying it was when he was not supposed to be there. And then another email here where he says in this, you know, it looks like it's from Mr. Dowser. He says, I can't stand her. You're putting together the animus expressed in those messages, though some of it not. I mean, the one is expected to you, you're fake. The other one, I can't stand her, is him talking to someone else about you. And then his presence, when he's been out, no trespass, and he appears to be moving into the areas where you're present and he's not supposed to be.
Correct. There was also one additional text message I received from a parent. I did reach out to the parent and to the player.
Okay,
was it
included? Did you include the
Yes.
text?
Yes, sir. That was included with the original PPO.
Was this the
request.
one at the gym about the old rugby player kind of thing?
Correct.
Okay, yeah, that would definitely be hearsay about under any definition of it. But the good news is, you know, you need to establish 2 incidents that might make you feel harassed or threatened. You've established more than that, so that's enough to sustain the PPO. However, I'll hear any cross-examination from Mr. Nolan at this time, and then at least hear an initial argument and whether or not we need to continue the hearing. So, Mr. Nolan, you may cross-examine.
Thank you, Judge Rossi. Ms. Quinone, you sought out this personal protection order on an ex parte basis. Is that correct?
I sought the personal protection order for my safety. The ex parte was the only option afforded online.
That's what I asked you.
You asked
And
me if I specifically
this was on
requested it.
June. This was on June 4th of this year, 2025.
I look at the original date. I believe that is correct.
And you
You're
were
asking. Sorry, go ahead.
You were petitioning the court for an order to restrain certain conduct. Is that correct?
I petitioned the court so that he could not be near me, correct? Or contact me.
Well, I'm asking you if you petitioned the court for certain protection.
That would be a true statement. Yes.
And did you fill that request for the ex parte order before Judge Rossi yourself, or did you have somebody else help fill you in?
I submitted the petition myself.
Did you get together with Mr. Gent before you filed this and check the boxes?
No, Mr. Gent was not involved in the
Was
or anything else that was going on.
Was Mrs. Gent?
No.
So you asked the court, you checked the boxes with an X, is that correct?
I think we've established that I am the one that submitted the petition and filled it out. That is correct.
So that's a yes answer. Some of these will be yes or no. Stalking, has he followed you or appeared within your sight?
Yes, on 4 occasions.
Well, that's a compound question, I'm sorry. Has he followed you?
Followed me? Like
Yes. Followed you.
on
places.
June 14th, yes.
On June 14th, but you filed this petition on June 4th.
Correct. That's because he was stalking me. And made
So where was he stalking you? Was he following you to your home?
it was at the rugby stadium on Rockford Public Schools property. where he sought me
Okay,
out.
was that a tournament that was being held there with a bunch of maybe 10 or 11 girls teams and 10 or 11 boys teams?
No, that was our
Did
senior.
Mr. Dowser coach your son?
No, he was relieved of that duty.
Well, so he did coach him, but you're saying he was relieved.
Correct.
Was that because you had something to do with that?
No, I don't
Was he
have the power to
did
have
he-
anybody removed.
Did he coach your daughter?
In the past, he has been a coach of my daughters, correct?
And he's coached as a volunteer many of the girls' teams that girls were sent on to scholarships on Ivy League schools such as Harvard or Yale or.
I wouldn't know that, nor do I feel that's relevant.
Well, wait a second. Weren't you a parent of children? How many children do you have?
I don't believe that's relevant to this proceeding.
Well, how many? You just have to answer yes or no. Do you have children?
Yes, I have children.
You have two children, a boy and a girl that he coached both of them on.
Yes,
So is this about the past? How many years ago did he coach your son?
I have known Mr. Dowser for 7 years, if that is what you're trying to get to.
Is it have you had a good relationship with him for 7 years?
Up until he thought I got him fired, yes.
Okay, and so that was in May of this year?
Correct.
Did you ever feel threatened by entrusting your children to him as their coach during the 7 years previous to May of 2025?
Can you repeat the question, please?
Sure. Did you ever feel threatened when you entrusted your children to him for the last 5 years prior to May of 2025?
Prior to May of this year, I had not felt threatened by Mr. Dowser, no.
And you entrusted your children, both a boy and a girl, to him. Is that correct?
I think you're reading a little into what that's saying. If you're asking if I allowed my children to participate on a team he was coaching, that would be correct.
Thank you. Thank you. And you never complained, did you? About Mr. Dowser prior to May of 2025?
No, I'd also not been threatened prior to May.
Well, I see you maybe it's a idiosyncrasy, but you tend to laugh after you say that. I think
I'm not
Mr.
laughing.
Mr. Dowser is looking at it as a pretty serious thing that you're requesting a judicial court like Judge Rossi to issue an injunction or preliminary.
I just fail to see where this line of questioning is going. If we want to talk about the facts, sir, the fact is the way your client behaved was irreprehensible.
I'll let you respond afterwards. You'll have a chance to do what's a reply statement to what you've been asked about if you want to clarify anything. But just for now, try to answer Mr. Nolan's questions because, as I said, we're on a sort of a time frame. So the faster I get the information on the record, the better we are. So you may continue, Mr. Nolan.
Thank you, Your Honor.
Thank you, Jan. So did he ever follow you or stalk you? Where did he follow you to? You mean from one end of the field to the other?
I don't, on June 14th, correct. It was from one field to another field.
Isn't it true that you went to the bench where he was sitting watching the games and videotaped him?
No, I've never sat next to him, nor did I videotape him.
I didn't say you sat next to him. Listen to my question, because and I'd appreciate it. I don't think this is funny. Maybe that's just an idiosyncratic habit that you have, but you laugh after this, and I've just asked that you just answer the question. I don't think it's funny. You've gone out and you've asked that he should not approach you or confront you in a public place or on private property, correct?
Correct.
And you asked the judge to issue an order to that effect. Is that correct?
Correct.
Has he entered onto or remained on property owned, leased, or occupied by you?
Not since the PPO was enforced.
When did he do it before then?
Not on property I owned.
Okay, that's one of them. On property that you leased,
No.
on property that you occupied by the patient, occupied.
As in my place of employment, yes.
And what was that at? Rugby tournaments or games on the soccer field or the rugby field?
He came to the rugby stadium and came to a tournament that we were at.
Did he ever come into your office at Rockford Public Schools?
No.
Did he ever threaten you at your place of employment?
Threaten me to my face at my place of employment? No.
You're asking that he not send any mail or communications, is that correct?
Correct.
And that he not contact you by telephone. Has he contacted you by telephone?
Not since the PPO has been enforced.
Had he done that before, contacted you by telephone?
Yes.
And when was that?
Aside from the text messages that I presented in court,
Before the PPO, correct.
all of the text messages that we have mentioned prior to these questions, and I have been in fairly constant communication with him as I was the team mom for the girls rugby team this past fall, of
And
which
there
he
was a-
was the head coach until he left for medical reasons.
And did the other coach, Sean, did he leave for medical reasons?
Not during the girls' seasons, no.
Okay, so when is the girls' season?
In the fall, usually August through November-ish.
And these are high school age children, correct?
Correct.
And when is the boys' season?
Usually February through June.
And you never had a complaint with him about your son playing for him or being coached by him?
He didn't specifically
Is
coach
that
my
correct?
son. He did not directly coach my son. He was one of the assistant coaches, but he was not the one that directly coached my son.
Oh, okay, you got me on that. So what you're saying is, I use the word coach, and coach means to you head coach, and so you're saying he didn't head coach my son. But if I
No,
use the
that's
word
not what I'm
coach,
saying.
are you agreeing that assistant coach is a coach? Or do you think they don't say anything or do anything to the children? They just stand there like bumps on a log.
That is two separate questions, which I'm very happy to answer.
Good.
There are multiple coaches. If you're unfamiliar with rugby, there are different positions that have different coaches. There is a
Look.
head coach that is a, would you like me to finish?
Yes.
There
I
is a head
apologize.
coach. Thank you. There is a head coach that oversees the entire team. Then there are assistant coaches that coach specific positions. The forwards, the backs, the special teams, the kicker. There's multiple assistant coaches. And this year we had, I believe, approximately 5 assistant coaches. So while Mr. Dowser was originally one of the assistant coaches, he was not the coach that directly interacted with my son, if that's what you're asking.
Okay.
Right. And I hate to interrupt, but we are getting to that point, Mr. Nolan. I'm now well into the time that I am supposed to have started another 2 hearings, and I promised Lisa I would stay somewhat on track.
Yeah.
And I guess the 2
apologize.
options, we can continue this to a future date, and I can set aside a full hour or whatever we need to get it finished. Or we could make a brief closing argument now and then continue. How would you like to handle it, Mr. Nolan?
Well, if we can do it in the near future, Your Honor, I'd like to do it because obviously it's a 6-month PPO,
Yes.
but my client is a assistant coach for the women's team at Aquinas College. He's very well respected, and this is a parent that was involved. They got into an argument. I coached travel hockey for 9 years, and I understand that parents always aren't happy. But I had a number of assistant coaches, and I didn't define those as non-coaches because they were only coaching the defense.
No, I get it. Well, and I guess here's what I'm driving at is now in his position with Aquinas, is he going to have any occasion to be up in Rockford? Does Aquinas play any matches or scrimmages or anything of that nature up there?
Well, I think that he's been to the field because he coaches a club team for youth, both. I know he did both boys and girls, but because of the situation, and this is all volunteer, and I'm sure, Your Honor, you're aware of the many hours that a lot of people put forth because they want to help people advance in a certain sport.
We want to help our kids participate in what they like to do. I hear you.
But this was a dispute between money that was being used from the girls' club that Mr. Dowser handled and coached and separated fundraiser, and was being used for the boys' team. And Miss Quinone was using that money to pay for the boys' expenses.
Well, I don't want to get too far into the weeds on the underlying part here. I guess what I'm trying to ask is, well, first of all, let me see when we can get that hearing date, because soon is a relative term in the legal world, as you know, Mr.
Right,
Nolan.
right.
Lisa, when can we set it? Give this an extra hour?
September 25 at 11 on Zoom.
All right, that is a little ways out in the future because we're only at August 1st now, and I guess what I was trying to drive at is if the order stays in place, is it going to limit Mr. Dowser in any way from doing his job as an assistant at Aquinas?
Your Honor, may I have Mr. Dowser just address that? Maybe.
Yeah, go ahead, Mr. Dowser. Why don't you speak to that issue?
You're on mute, Andy. Can you take yourself off mute?
Yep.
Can you talk?
Yes. It will not have any effect on my employment with Aquinas University. I would like to just add 3 quick facts. I was never hired by Rockford. I never received any type of paperwork or contract. I just had to pass a fingerprint scan, basically, to keep my job every year. I was never paid anything.
Yeah, no,
Never
I never suspected this. Any of these were paid positions. Just knowing the nature of rugby in general and club sports in general as well. I know that, and even the paid coaches, I think we figured out one time we were paying our wrestling coach about $1 an hour, for all the time he put in with the kids. So, yeah, it's not if it's paid, it's not well paid. So, however, growing up with a dad who was a coach in the Catholic schools, I totally understood that. So, I'm pretty sure he did it because he loved it, not because he was making any money doing that. So what I'm going to do here is let's continue this on the 25th as stated, since it's not going to impact Mr. Dowser's day-to-day. Or is there something you want to add, Mr. Dowser?
It affects my day-to-day because I'm a real estate appraiser. I go in and out of people's houses. I can't have this on my record. And as far as the no trespassing goes, that was issued May 29th. By the school. I never broke that in any way. The PPO was issued on 6/14, and I was coaching at a tournament that day. So yes, I am going to be at these tournaments. We did not have any interaction with Miss Quinonas on that day that she cites.
Yeah, I think we're going to have to hash this out at the hearing. I hear your concern about the
conversation.
Yeah, no, we're going to have to just have you sworn in, and you can give testimony, and then Ms. Quinones will have to have the chance to cross-examine you. I just don't have time to get the full story out today. Sometimes these can be resolved fairly quickly. But as I think that through, that's only when only one of the parties shows up, and then they automatically win or lose. In this case, since we got both parties and both parties are able to testify, no one's going to voluntarily dismiss that. It doesn't sound like sometimes that happens as well. We just simply have to set, because of my schedule, for a different day. In the meantime, it shouldn't, these are civil orders. They wouldn't show, for example, if someone ran a background check on you, they're not going to show as an arrest, a conviction, or anything like that would have any basis for a realtor, as long as you're not going on Ms. Quinonas' property to buy or sell property. I don't think it's going to have any limiting impact on your ability to, practice your profession. If you dispute that and you want to file something written with Mr. Nolan, I can reconsider that even between the two hearings and issue a written opinion. But because I don't like to, deprive anyone of their ability to make a living doing these. These are basically called peace bonds that kind of separate the parties from a reasonable distance from each other until things cool down. And as Mr. Nolan pointed out, that's why they're relatively short in duration. So I don't think it's going to keep you from earning a living as a realtor. In short, Mr. Dowser, I know it's not anything anyone wants to necessarily have floating out there, but these are limited in their application to any interactions between you and the petitioner. They're personal, as the title of the order states. So at this time, I'm just going to have to continue the hearing. The order will remain in place, and we'll continue it on September 25th.
Your Honor, may I just have a couple of questions? First, I'd like to say, Mr. Dowser does not have a hand or a long rifle or anything else. He doesn't carry a so that's not a threat. But I cannot, as an agent, I'm bound by Your Honor's order, and I can't reach out to Mrs. Quinones like we could if she had an attorney, or if there wasn't a PPO preventing an agent or representative contacting her. But I would invite her to see if we could get this resolved somehow, and before that date where we're going to take up the court's time. I don't think Mr. Dowser's has any contact. I'd like to simplify this. I understand that there's some animus between the two. I'm not blaming her. I'm not blaming him. It exists. But if the period of time that we've had since Your Honor issued the order, there's been no contact and no phone messages and no text, and he shows up at a team tournament on a ground where Mrs.
She's also there because
Quinones,
her kid plays. I get it. No, and
Right.
I've encountered that sports team conflict before with PPOs, and sometimes you can work it out. Ms. Quinones, do you intend to retain an attorney in this matter?
I hadn't thought I would need an attorney.
Well, would you, and I guess then that leads into my next question is, would you be comfortable if Mr. Nolan reached out to you? It would be obviously in a professional sense. He's the attorney for Mr. Dowser, but the purpose for him reaching out to you would be to craft a more tailored protective order, if we could, that would protect your interests, but also let Mr. Dowser go about his day. There are a variety of ways to do that. There's no real magic to a personal protective order that makes it different than any other type of court order. And the other advantage to you is there. You could explore, I guess, would you be comfortable with Mr. Nolan contacting you directly?
I'm going to be quite transparent here, Your Honor. I don't feel there's any point, because I do not intend to offer any
Change it or modify
Yes,
it
like
without a court order. Okay.
Correct. I do not feel, I wholeheartedly feel that the only reason he hasn't contacted me or been around me is due to the personal protection order, which prevents him from doing so. I don't believe that Mr. Mr. Nolan could offer me any kind of personal relief that would assure me that he would stay away. And quite frankly, the reasons in their petition to terminate, or their motion to terminate, don't hold water for me. I don't believe that this personal protection order affects his livelihood in any way. He said clearly it won't affect his job at Aquinas. It shouldn't affect his job as an appraiser because I would not be asking him to appraise any property I was looking at or owned. I do, however, believe that this personal protection order is the only thing keeping myself breathing right now. I don't
Well,
take this
Okay.
lightly
Well-
and wouldn't have asked
Well-
for it if I didn't feel it was absolutely necessary.
Okay, well, and I don't know, of course, the depths of the, the interpersonal relationship here. I will say, if it's any reassurance, generally when someone shows up to one of these with an attorney, it means they're taking the legal part of it seriously, and that's the avenue they're going to pursue rather than, these are designed to prevent that exact sort of thing where it's self-help and people are breaking other people's windows or beating them up and stuff of that nature. And just simply in my, again, brief experience with you, well, not brief, now I've done these for 4 or 5 years. When someone appears at the hearing and makes, genuine legal arguments with an attorney, that means they're going to take the legal road. So if that's any assurance to you, that appears to be the, the path that Mr. Dowser has chosen. However, it is your order, so it's in your court. We'll just continue with the hearing. If you change your mind or you think there's something perhaps you can work out with Mr. Nolan, that along the lines of a compromise and then not have the necessity of that hearing, I'm always open to that as long as it's agreed to and signed off on by both parties. So otherwise, I'll see the both of you at the end of August because I've really got to go now. Or Lisa's gonna, I'm gonna need a protective order against her.
I don't want Lisa upset with you, Your Honor, but I will say that I'm taken aback by the fact that she says that the only reason she's alive because insinuates that Mr. Dowser would commit
I'm not
murder.
seeing that anywhere in here, but then I take it in the context of, well, he is a rugby coach. They are rugby players, as I was once, are known to be rough and tumble. However, I haven't seen any indication of that either. And the very fact that, of course, he's coaching young people would militate against that as well. So I don't perceive there as being an enormous risk of physical violence here. I'm just trying to keep the peace, as it were, by keeping the order in place until we can have the full-blown hearing. So with my thanks to all parties for showing up this afternoon, with that, the matter's adjourned.
Thank you.
Thank you, Your Honor.
Thank you.
All right, this is the matter of Reagan versus Reagan, case number 21-06138-DM. Present in the virtual courtroom, we have both parties as well as their respective attorneys. We're here on the defendant's motion to object to the recommended order of the referee. The court has read the objection and the response. And the court also notes that this court did enter an order on July 1st that indicated that pursuant to the court rule, no additional testimony will be taken from either party unless a proper motion is timely filed requesting permission. So with that background, Mr. G.
Sure. Your Honor, first I'd like to address the procedural issues with this matter. As you're aware, my client's objection indicated she wasn't aware of the hearing that was to take place on June 6th of 2025. The court rules MCR 2.107G provides for email service. Now, I've had plenty of conversations with other attorneys and we haven't reached a consensus and there's no case law on it yet, whether that means the email service is to supplement regular service or if it's to replace normal mail service, because the court rule uses the word notwithstanding, but it doesn't say in addition to or instead of. Now, the interesting thing though, what the certain deficiency here though, is that 2.107G indicates that the email service must be performed in conformity with 2.107C4. C4 is the rule concerning when the parties stipulate to email service, to electronic service. And subsection F requires that each email or text message in the subject line contain the title of the document being sent. And that is not the case. The email in this service had the case name and the case number in the subject line, and that's it. So the email service was deficient in that respect. Also 2.107 indicates, email isn't sufficient when you have a new action. Well, we have a closed case here. And it's essentially being reopened. I think probably due process requires more notification to Miss Reagan than a simple deficient email. So I'd ask that the court set aside the temporary order. There's certain parts of the temporary order that will stipulate to, but I think the court should set aside the temporary order and send it back to the referee for a redo of the hearing that occurred on June 6th, where my client can be present and myself will be present with her as well.
Man, go ahead. Mr. G, did you have something else you wanted to say?
I just addressed the procedural aspect. I don't know if you want to let Ms. Van Horn respond to that portion.
I think that's the best way to go about this. Ms. Van Horn Feigelman.
Thank you, Your Honor. First of all, under 2.107G, it says, until further order of this court, all service of process except for case initiation must be performed using electronic means, including email service. So it says must. And so I don't know how Mr. G can properly argue that I somehow improperly served her by using, by the way, Your Honor, the email address she put in her own objection filing on page 5. Also, I would just note for the court that the court rule 3.215 does not allow Mr. G to raise new things today that were not raised in the objection that was filed by his client. He certainly could have amended his objection after he entered his appearance, and your order specifically allows such an amendment after the transcript is ordered, but he did not amend his objection to include something about improper service. I'm sure the court has noticed in the objection that Mr. G's client filed, she specifically said she was having problems with people stealing her mail, and that's why she didn't get the notice. And now they're raising this issue about email service being improper. It's certainly not improper, and I don't know how else you can interpret the word must other than it has to be done that way. So I don't know why Ms. Reagan did not read her email. She certainly has endorsed that as her email address. We were certain that that's the email she was using, for example, to email my client, to email principals at the school, to email therapists. So we knew that was her proper email address when we served her there. And I can respond to the substance of the objection if you want, but that's my response to the procedural objection that was never raised before today.
Well, the court's reading of the objection to begin with, well, I guess that would be getting into the substance, but procedurally, I think it is deficient. The email service, especially when it results in actual notice, is sufficient in this court's mind, especially in an ongoing and very litigious case such as this. And I think she got actual notice. And so if there's a technical deficiency here, which I don't think there is, it comes down to whether she got actual notice, and if she did, due process has not been destroyed or impaired. So I will find that the objection does not comply with the court rules. I will deny it. I know this is at the front of the court, and so this isn't the end of the line for this case, and we'll go from there.
Your Honor, can I address the substance of the objection?
I'm finding it's procedural. The objection is procedurally deficient, so we don't need to get to the substance.
I guess I understand. What is procedurally deficient about the objection then?
Her objection is based on no notice and the inability to appear. I'm finding she actually got notice, did not appear. And therefore, when you add that to the court rule regarding no additional evidence being taken that was not presented at the original hearing, there's nothing else to talk about at this point.
Well, okay, just for the record, I would like to make an argument about the order that was actually entered, that it's not in the best interest of the child, and it doesn't reflect the therapist's recommendation. May I proceed in that respect?
I suppose you could place it on the record that it's I've made my decision.
Thank you. Well, the therapist specifically, she talks that Miguel has these issues of verbal abuse. I don't know where she got this information from, whether it's the plaintiff or whether it was the child. I've run into this many other cases where if the therapist hears the side of the story from the other parent, then the recommendation has changed. But anyways, in this particular recommendation, she says that Miguel is fearful that his mother will be cut out of his life. And so this order does exactly that. It reduces her parenting time by 70 or 80%. And so I think there's ways that this could be addressed. I think that the referee could have ordered my client and Miguel to attend therapy together, for my client to speak with a therapist. I think there's less intrusive ways. I don't think there's an emergency. This child hasn't been the subject of CPS investigations or physical abuse. There's an allegation of mental abuse, but we don't have any testimony to that respect, or even an affidavit of somebody that's seen my client abuse Miguel. So I think rather than destroying her established custodial environment through a temporary order, I think maybe it'd be appropriate to use a less drastic means to address this issue while this matter is pending. I mean, we're pulling this child out of the home he's lived in his entire life. We're pulling him out of the neighborhood he's lived in. He's going to be moved away from all of his friends, and to live with his father who works full time, versus my client who's available to the child most of the time. But that's all I have, Your Honor.
Great. Mrs. Van Horn, Feiffelman, I gave him an opportunity. You can have the same opportunity to make a record.
Yeah, I know the court has already made its ruling on the objection, and I'm happy to draft the order on that. One thing I was going to ask the court either way today is I have had a conversation with Ms. Dart, who is the therapist. Unfortunately, even since this order was entered, Ms. Reagan has continued to talk to Miguel about this case, get him to write text messages to his dad saying that he wants to change custody and parenting time, calling dad names like the devil, an abuser, a manipulator, etc. And Ms. Dart is very concerned about the fact that even with this pending, Ms. Reagan is continuing to do these things to Miguel. As I indicated in my objection, this kid is a very articulate 13-year-old boy that's going to be able to tell these things to whoever interviews him, including Ms. Dart. And I'm just asking the court, in addition to denying the objection today, to also enter a mutual restraining order where neither party can discuss the court proceedings, custody, parenting time with Miguel. We already have a front of the court meeting set on August 18th. That's great. But the pressure that's being put on him by his mom, there's tons of evidence of it, and I won't go into it all because I know the court's already made its ruling, but Ms. Dart is very concerned about the fact that even with the court looking right at her, she's still doing this. So if we could get a mutual restraining order, just restraining both of the parties from discussing any court matters, custody, parenting time, etc. I think that hopefully will diffuse that situation a little bit. So I'm asking that in addition to the order denying the objection, that we add a mutual restraining order type language.
Mr. G, do you have it?
We'll stipulate to that. That's fine. We have no objection to that.
Okay. And I will emphasize that that is the absolute worst thing either one of you can do for this child. So no matter how much you hate each other, don't drag him into it. He's a kid. All right. Anything else?
Nope, that's it, Your Honor. I'll draft the order. Thank you.
All right. Thank you. We're adjourned.
Case number 1809285 DS, Lache versus Shears.
All right. First on my screen is, it looks like Shakita, is it pronounced Lache?
Yep, first name is Shaquita Lache.
I had a
Good morning.
50-50 chance. I always lose that, but it's a beautiful name and good morning.
Thank you. Good morning.
And Jelani Shears joins us. Mr. Shears, next on my screen. Good morning.
Good morning.
So this is your motion, Mr. Shears. I have read your motion, and I have also received a response from Ms. Lache, and I've read that as well. So my first question will be with the plaintiff. Have you received a copy of the motion, Ms. Lache?
Yes, I had to go down to the court. Oops. Can you see me? My screen is freezing.
Yes, I got you.
Okay. Yep, I got it from the county clerk.
Okay.
Last week Friday.
And
What did you?
Mr. Shears, did you receive a copy of her response?
No, I have not.
Your Honor, I do have a receipt here from the Postal Service saying that it was mailed to that address.
Okay, it says, well, and there's a proof of service that says 725. But do you two generally communicate at all, or are you two not even doing that?
No, Mr. Shears, he does reach out to me on Messenger, so he does initiate communication on his end, but I do not respond.
Okay, because what I would like to have done is I would like him to have a copy of your response, and I'm trying to see how the best way to get that to him, whether it be in the mail, but the easiest way to do it is to scan it and email it, so he gets it immediately. Do you have an email address, Mr. Shears?
Yes, I do.
Why don't you give it to me?
It's my first name, Jelani, Jelani, Shears, SHEARS @iCloud.com.
You got that, Ms. Lache?
Yes. Mm-hmm.
Okay, so just scan it and ship it over by email, and then he's got it, and you can read it later today, Mr. Shears. But I have read your motion. Is there anything you would like to add to the motion before we hear from Ms. Lache?
No.
Okay, thank you. Ms. Lache, your thoughts, please.
Because I don't want to go on a tangent. However, with me receiving this last minute, I did not have enough time to allocate evidence to show, but showing up today as in good faith, I always try to do what's best for the children. We have a FOC case as well. On the documentations, it will show his inability, like there's a pattern. He doesn't have a stable housing. I'm unsure why he did not receive the motion because I used the address that was listed on the motion. Also, him filing incorrectly. I'm also looking into getting his rights terminated because this has been a lot where the kids are in therapy. I've gone to therapy myself, and yeah, I just don't want to go on a tangent. That's all I want to say.
Okay. So I have, here's what I know. The parties appeared for mediation at the front of the court on February 11 of 2025, and the matter was not resolved. And I want you both to remember that when this case concludes, because I will almost guarantee you both will be kicking yourself for not taking advantage of that mediation, because this is really the last opportunity to control your own destiny, so to speak, in this case, because now it goes from the parties being able to sit down and maybe not come up with a perfect solution, but one that they can work with and go into the future with. But now I have to get involved with it. And a lot of people don't like when courts have to make decisions about kids they never met. But maybe this will work out for each one of you. I don't know. The last parenting time order was the March 5 of 2019 judgment of support. Parenting time was set by the agreement of the parties. According to the motion, and there's always more to it, I know that, but if I've heard this once, I've heard it 1,000 times on these motions. Motion states everything's going great, and then the parties have an argument and it stops. I hear that constantly, and I know there's obviously two sides to every story. That might not be how Miss Lache sees it, but be that as it may, there are irregularities in service. I get that. And I'm always willing to tell the other side that I would be happy to adjourn this matter and for a couple of weeks and then allow for proper service, that type of thing. But I will tell you, I'm going to do what I'm going to do regardless. So if it probably would not behoove you to take time out of your days to do this. So the lead case in parenting time is the case of Shade versus Wright, 291 Michigan Appeal 17. That is a 2010 case. And what that would say, that says to me that proper cause or change of circumstance has been shown to take a look at parenting time, because there's really not anything to enforce. And parties need, children need, everybody needs structure in these areas. I will also note the unpublished decision of Bauman versus Hartman, that decision not being precedentially binding on this court, but certainly persuasive. And I find that poor communication and lack of cooperation between parents does constitute a change of circumstance to revisit parenting time. The relevant best interest factors are found at MCL 722.23J, because it diminishes each parent's ability to encourage and foster a close and continuing parent-child relationship between the other party and the minor child or children. So reluctantly, because like I said, I don't take lightly getting involved in people's business. So reluctantly, I am going to send the matter to the friend of the court for a complete investigation and recommendation insofar as parenting time is concerned. Additionally, there is a request for custody, and it appears anyway that it's not, there's certainly no proper cause or change of circumstance to even do that. So I'm not going to get into that involved, but I'm just going to refer it to parenting time for parenting time. And let me ask you this, Ms. Lache, are you currently employed?
Yes.
And Mr. Shears, are you currently employed?
Yes.
Okay, so I'm going to send it to the friend of the court. There is a fee for that, and I normally split it. And the fee is $300, so half of that's $150. And they will let you know. Keep in touch with the friend of the court. Make sure they have your correct information. You got to know where to pay the when and where to pay the money. And they will do a deep dive into this. They'll talk to whoever you want them to talk to. They will, sometimes they'll speak to the children, maybe not. And they will review whatever records you want them to review. And then they will make a recommendation to me. And then the parties are free to accept it. They're free to use it as a tool to negotiate from, or they're free to say, nope, I don't like it. And then when that happens, it comes in front of me in by way of an evidentiary hearing. And that's when it gets pretty complicated, because the rules of evidence apply. I can give some grace to people who are unrepresented, but I still have to treat y'all like attorneys. So you can, I'm going to do the order of reference today, and you should be hearing from the friend of the court relatively quickly. I would say if you haven't heard from them by a week, I would call them and make sure they have your proper credentials, because they don't forward mail. So, and I hate for people to run into this problem at this point. Okay. Ms. Lache, anything further?
Nope.
How about you, Mr. Shears?
No.
All right, you both are all set. Have a wonderful weekend, and don't stop trying to get this resolved, okay?
I have one question though. I don't know if this is possible, but is there any way that I can like at least talk to my kids? Like,
well, I usually don't start with interim relief. You can file your own motion if she's not allowing contact, and I will entertain a interim schedule of parenting time, but I need more facts. Okay, so if you wish to do that, then bring it on in another motion and let me have all kinds of facts as to what kind of parenting time you had in the past, what you're looking for in the future, what type, this type of thing. Okay.
Okay.
You are all set with me. Have a great weekend, you two, and we're adjourned. All right. First on my screen, on behalf of plaintiff Kaylin Zurkel, attorney Jonathan Hexel. Mr. Hexel, good morning.
Good morning, Your Honor.
And Kaylin Zurkel joins us next. Ms. Zurkel, good morning.
Good morning.
And Mr. Kyle Zurkel joins us as well. Good morning.
Good morning, Your Honor.
So I have received a copy of a objection to the friend of the court recommendation. I wish I didn't, but I do. And because it's things start moving at a quicker pace than that. So let me just create a record and then I'll turn to you, Mr. Hexel, and then we'll turn to Mr. Zurkel. So this matter was previously in court on the 19th of May of 2025. Parties actually stipulated to a child support review, and an order of reference was entered on May 20th of 2025. On June 30th of 2025, the court received the friend of the court child support recommendation and orders. On July 17th of 2025, plaintiff filed an objection. Therefore, it was a timely objection. So where it goes from here, folks, is it gets exponentially more complicated. And we set the matter up for an evidentiary hearing. Usually on child support, Mr. Hexel, I start with an hour, and then we work our way on from there if it needs to go further. But when you get notice of this evidentiary hearing, it's also going to have some very important filing requirements: briefs, witness lists, exhibits, exhibit lists, those types of things. And failure to do those things or do them correctly could result in your hearing being postponed or adjourned, or if enough of them happened, even canceled. So pay particular attention to that. If anybody is considering hiring an attorney for this matter, then they ought to do so in the real near future. Also, the date for these must also be cleared through the friend of the court evaluator, whoever did the evaluation, to make sure they are not tied up in another hearing or on vacation or on medical leave, so we don't have to adjourn that matter. So, Mr. Hexel, I have one question, and then I'll turn it over to you. Normally, I always inquire in these cases if you think mediation would be an appropriate avenue to try and settle this, or is that just not an appropriate way to do this?
Your Honor, I would actually defer that question to Mr. Zurkel. I'm always open to mediation. I believe it's a great process and a great opportunity for these clients to work this out themselves without litigation. And I think Ms. Zurkel would be willing to do that. So I would defer to Mr. Zurkel.
What do you think, Mr. Zurkel? You think a mediator can help get these issues resolved?
Your Honor, I have been trying to settle on this matter. Mr. Hexel is a fabulous attorney and a great salesman as well. But his general accounting practices are, I'm not really seeing how he's getting these numbers. I wasn't a huge, fan of the FOC result. I thought it was rather high because they did factor a bonus in there. So I just, went with their professional opinion and thought it was going to be okay, and I was going to go with it. However, as you see there, the plaintiff wants even more. And then not only even more, but to continue to do this every single year. If you look at our past history, the plaintiff has filed multiple motions every single year since the judgment of divorce. It's kind of a living hell looking at my email and just being fearful of another email from Jonathan Hexel. I respect him as an attorney, absolutely. However, they've caused a lot of grief, and I would just really don't want to just bend over to these terms. I think that the FOC statement is, yes, high. I'm willing to go with it, but for them to ask for even more, I got to draw the line somewhere. I do believe that we should, if they do in fact want to fight this, we should take this to court. There are a lot of things that I would like to subpoena. There is a family business that wasn't factored into the FOC judgment. I think that those figures need to be presented. I'd like to see a profit and loss statement of the Groundhog organization where Kaylin works, and it's a family-run business, so I know that there's multiple incentives along with that. I can understand too if, say she was a single mother living on her own, but she is like very well compensated, drives a brand new truck, lives in a, big house with her extended family. I don't see a reason for wanting even more. Even seeing how there was a sign-on bonus and a incentive bonus factored into the calculation. So say next quarter I don't get those bonuses, I'm still paying that $1,080 a month, right? Which is 8 times the typical child support payment for the amount of nights that I'm getting as well.
So we're off to a bad start, you and me. And I'll tell you why. Because I just asked you if you thought mediation would be appropriate, and then you've gone into a 10-minute dialogue and answered and asked and everything but what I asked for. Okay. We're not here to try the case. We're not here to get your thoughts on the case because there's been an objection. It's not that your thoughts aren't important. They're just not important today, because what I have to do when there's an objection is I have to set it for an evidentiary hearing. But I try and ask the parties if they believe that a neutral third party couldn't help them with the possibility of getting this matter resolved once and for all. And I was just looking for a yes or looking for a no from you, because mediation adds an expense, and I don't want to do that if the parties are not mindful of its ability to resolve the case. So let me try it again. Do you feel mediation would be beneficial, yes or no?
My apologies, Your Honor. No, I do not.
Okay, then we'll set it for an evidentiary hearing. And you can get with my clerk, Mr. Hexel, probably starting next week. You also get with the friend of the court, whoever did the evaluation, and then we'll get it teed up for about an hour. Mr. Zurkel, I would, based on what I've heard today, I would strongly urge you to retain counsel, because some of the things you are asking for, although relevant, may be difficult for someone who is representing themselves to get. So, but the Sixth Amendment lives alive in my courtroom, so you are free to do this on your own. And hopefully things will work out for the best. Otherwise, we'll see everybody in court. Make sure you keep in mind the filing requirements, submission requirements, and we'll get that squared up for you. You're all set with me. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
6 Corvius versus Gonzalez.
That's correct.
Who's correct?
Gonzalez, because they had me as Lisbeth Rascon.
Last names are interesting because you get different ones depending on who sends in the material. So this is, it looks like George's motion for an objection to the friend of the court. So what did the friend of the court do that you object to? You're on mute, by the way, because I can't hear you. Still can't hear you, George. You're on mute.
Okay. Oh, sorry. Good morning.
Good morning.
So the last time we were here at court, you ordered that we go to review parenting time with friend of the court, and we pay $150. She pays $150. So I kept keeping in track with friend of the court, and they told me that she wasn't going to pay the $150. So I asked them what I have to do so I can get parenting time, because I've been trying to get more parenting time with my daughter. And they told me I had to file an objection, and now we're here. So, yeah, that's pretty much why we're here, is because she didn't pay her $150. And then it kind of got very frustrating because she didn't pay her $150, and at the time she was going on vacation to Arizona. So I'm like, you ordered a court order and she just blows it off like nothing. So it's a little frustrating, and I got to go through all these loops to try to do what I have to do to get more parenting time. So it just feels like she just blows it off, and it doesn't matter what you say. So
It doesn't.
no, it does matter to me what you say.
Miss Gonzalez, what say you?
I did travel to Mexico, but it's not like he's putting it. I went to Mexico because my brother sent me money to take stuff to my mom because she moved back to Mexico. So we needed to take her stuff. He knew that my daughter was coming along with me. I didn't pay the $150 because he has the support. He lives with his parents and he works. I am here in Michigan by myself. All my family is in Arizona and Mexico. So I get financial help from the government. And I went to the front of the court as well and tell them how we can waive the fees. And they tell me the same thing about submitting a paper to talk to the judge and kind of see if the judge can help me waive the fees.
I'm not waiving the fees.
Okay.
I'm not. It's $150.
Mm-hmm.
You can't come up with $150.
I get assistance from the government.
That's besides the point. It's $150.
Mm-hmm.
Okay. And you can't tell me that something this important, okay,
Mm-hmm.
that you don't have $150. You don't have anybody you can borrow it from?
Like last month, I didn't work for a whole month. I work in construction, so I get work here and there. I had to pay my insurance, my rent, my phones, my kids.
Okay, I got the perfect solution then. George, here's what we're going to do. I'm going to resend it over there. I'm going to have you pay the $300. And then when we get to an evidentiary hearing, I will order Miss Gonzalez to pay the $300 back to you. So she just cost herself $150. But I don't want to stop things anymore. And if anybody else decides to violate one of my orders, there's going to be a lot more at stake than $150. So I hope you both know that. So I'll order you pay the fees, George, but you're going to get them all back from her. Okay.
Okay.
All
Okay.
right. I'll do the order right now.
Your Honor, just one quick question real quick. So they haven't funded me back the $150. Can I just go and pay the other $150? And
yeah, however you do it.
Okay, I'll contact them and I'll pay the other $150. So that's because right now the money situation is not even the thing. It's just having more time with my daughter, because there's a lot of things Lisbeth's doing around Juliana, which is very alarming, and just things that's happening in the household. So
I already ruled on that, George.
Okay.
I said we're reopening this up.
Okay. Thank you, Your Honor.
It's just.
So when am I paying the $300 back to him?
When we get to a hearing, if we need it.
Okay.
Okay.
Okay. Thank you.
All right. I'll do the order today.
Thank you.
Thank you. Yep.
Bye-bye.
Okay, so I just really want to talk about the first one with Judge Rossi. That woman was, to me, it sounded like she was extremely spiteful and extremely childish. She just has to win. That's all it is. And it was a game. You know, she was laughing at the attorney that was asking her questions. She has no idea why he's asking her the questions he's asking. He's asking the questions to lay a foundation to impeach the witness. That's what he was doing. And I wish Judge Rossi had been a little stronger and just said, answer the question. Answer it. You know, you have no reason not to answer the question. But he's, you know, such a gentle man, and he just didn't do that. And he should have. He should have put his foot down. I think the attorney was really good, though. I think he pretty much held his own there, and which he should have been able to do. But anyway, it had something to do with $20. $20 that was fundraised for one team that was given to another. Fundraised for the girls in the same league or something, in the same school, I don't know, and given to the boys, or the other way around. It was raised for the boys and it was given to the girls. I don't know, but it was $20. I mean, come on, lady. You're going through all of this for $20. That's ridiculous. That's extremely spiteful, and it's childish. It's $20. Get over it. And then if she is that terrified of this person, why was she going to the games? Why did she continue to go? She could have dropped her little ones off. She didn't have to sit there and watch the whole time. She has every right to do that, but she has to make a big deal of it because, oh my gosh, I'm so scared. Come on. That was a game. It was a game that I'm going to get one up on you, dude. That's what it was. That's what the whole thing was about. That's in my opinion. Anyway, that's the one I really wanted to talk about. The second one with Judge McNabb, you know, that attorney was, he was outmatched. He was outmatched. So anyway, thank you guys so much for watching, and I'll see you another time.